We're now joining the meeting.
Good morning, everyone. I'll give everybody a chance to join in and then we'll talk. Morning, Your Honor. Good morning. All these stations.
Good morning. How are you?
I'm good. I'm like I said, I'm looking. I got Jessica Travis. I don't believe is in yet, and I don't have a screen big enough that's not necessarily showing everybody. There she is.
I'm here.
Good morning. In a second, I'll go through and see who we have. We'll address our court reporter, etc. But let's just wait a second so anybody that's interested has an opportunity to join in. And I know we had a bunch of interested people, but I don't necessarily have a list of non-parties. Okay, let me begin. I'm Judge Dugan, as you all know. This is the case of the Courier-Journal, DBA Florida Today, versus Wayne Ivey in his capacity as Sheriff of Brevard County, case 2020 CA 034489. I'm going to ask in just a second everybody introduce themselves. Before we do that, I'm going to have our court reporter introduce herself. Tell me who you are.
I am Liz Hanson with Ivey Global Litigation.
Okay. Thank you very much and welcome. All right. I'm going to ask as we go forward that everybody this is not an evidentiary hearing, so only the attorneys and myself, I guess, will be appropriate for us to speak. If y'all feel otherwise, let me know. It's always my belief to have a full and complete open hearing. I'm very happy that party representatives, and I'm very happy that members perhaps representing the public are involved. Like I said, I'm very pleased with that. I am going to ask that if you're not speaking, please mute. We've all done these hearings, and we know well that the background noise can destroy the hearing. So as far as your sound, mute when you're not talking. You all have largely practiced in front of me, so you know that I'm going to give you a complete opportunity to have your say. I'll do it in an orderly fashion, and I probably have some questions, but I'll hold those questions to see if they're answered by what you all present to me. So, contrary to saying please mute, I'm going to ask one by one, starting with the plaintiff, if you'll identify yourself for the record. So, plaintiff, attorney, and you can, I think you have some of your clients here, so if you can identify yourself and who you have participating.
Yes, good morning, Judge Dugan. This is Ed Burke for the plaintiff. With me is my associate, Logan McEwen. Client representatives are Mara Bellaby, executive editor at the newspaper, and Bobby Block, watchdog editor at the newspaper as well.
Okay, and for the defendant.
Good morning, Your Honor. Laura Moody on behalf of Wayne Ivey in his official capacity as the Sheriff of Brevard County. I'll let Mr. Cromash and Mr. Fulton represent them or introduce themselves, but they are also on the call.
Okay.
Good morning, Your Honor. This is Keith Cromash. I'm also appearing on behalf of Sheriff Ivey. Your Honor, this is Thomas Bolton, also appearing on behalf of Sheriff Ivey.
Okay, Miss Travis, I don't think you're a party, but this is your one opportunity to speak. If you'd like to identify yourself on the call and in what capacity you're present.
Your Honor, Jessica Travis, for the record, I'm just here as an observer, not as a party, so I'll mute myself.
All right, thank you so much. I'm very happy to have you here. Those are all the people I see on the call. Do I have anybody else that's not identified themselves? Apparently not.
We got Volusia Exposed out here. I'm listening to the call.
I'm sorry, go ahead.
VolusiaExposed.com.
All right. Very happy to have you. And on behalf of Volusia Exposed, would you like to introduce yourself?
Just Volusia Exposed.
Okay. Thank you for appearing. I honestly value your appearance. Okay. I'm looking at my notes. Now, as part of y'all done these hearings before, so attorneys. I know this is a case management conference. We're not going to be taking evidence. Probably not going to have any substantive argument. But if there is an objection or you feel you need to interrupt the speaker, feel free to do that. Wait to be recognized. I will address you, and we'll get all that covered. I want you to leave the hearing having the opportunity to have said everything you want to say. I have some questions and I have some thoughts, but I'm going to turn it over to the plaintiff to start. My question is going to be twofold. One, tell me what you want to tell me, but also what you're thinking. I know that there was a request for a 2-hour evidentiary hearing, and I've got some procedural questions that I need help with. And so, Ms. Burke, if you want to take the lead, talk to me. What are we doing here? What are you looking for?
May it please the court, Judge Dugan, thank you very much, Ed Burke from the newspaper. So what I'd like to do, Judge, is offer a roadmap. This is a slightly different proceeding than most civil proceedings because of this statute 119.11, which requires a accelerated hearing and immediate compliance is the title of the statute. So the roadmap that I would propose to stay within the bounds of this statute is the following. The court would today enter an order to show cause to the sheriff to show cause within 7 days why the video we're seeking should not be released. That would typically involve some kind of argument about their assertion of the exemption. Sheriff bears the burden custodian, records custodian bears the burden of showing that an exemption applies. At the same time, we would ask that the court order the sheriff to produce the disputed video, all of it, to the court to begin an in-camera review. And the reason for that is, rather than take this in steps in seriatim or in sequence, that would allow your honor to see the video when we get to, if we get to an evidentiary hearing, to inform questions and understand whether there actually needs to be a hearing. The purpose of the in-camera review also would be to determine if the asserted exemption, the security system exemption, actually applies. And there's no way to tell that until your honor looks at the video. We are unable to narrow the scope of the video because we don't know exactly what exists. And so we have to ask that the custodian sheriff be ordered to produce all the video to your honor. Now, if your honor should find that the claimed exemption does apply, we would need to have an immediate evidentiary hearing to determine our other theory of relief, which is the good cause exemption. Good cause exclusion to the security system exemption. So that would be the sequence we proposed. There should be no discovery in this case. I'm unaware of any public records action brought under 119.11 that involves discovery. The legislature has made it plain that through this statute and the case law construing it, I don't think there's any authority providing for discovery. So that's essentially our position and our recommendation at this point, Judge. I'd be happy to answer any questions.
I do have some questions, but let's see if Ms. Moody answers them for me. Ms. Moody, are you taking the lead?
I am, Your Honor. Firstly, I do believe that any evidentiary hearing in this case takes far more than 2 hours. So I just want to start with that preface. I believe we need at minimum a full day of hearing time. I would anticipate probably even 2 days of hearing time would be required for an evidentiary hearing. I'd also like to address the issue with regard to the manner in which the Florida Today has brought this complaint. I believe the rules of civil procedure still apply. I do not believe they're abrogated by Chapter 119, and therefore we are entitled to answer, to provide a responsive pleading to the complaint. They have alleged unlawful withholding of the video. They are seeking attorney's fees for unlawful withholding. They are seeking injunctive relief for any future causes of action. And as a result of that, merely asking for an order to show cause today with a 7-day response is not sufficient from the sheriff's perspective. We agreed to a service of process in this case that provided us until September 12th to provide an answer to the allegations in the complaint. The manner in which they brought this, they did not bring this as a writ of mandamus. They did not bring this in any manner other than a civil law complaint against us, and we're entitled to respond to that. So I'm going to ask the court to deny that request. I'm going to ask for sufficient time to respond to the allegations in the complaint. And then ultimately, I can agree with Mr. Burke. I do agree that it probably would be productive for the court to start a camera review of that video. I believe that's going to be required under the statute. So I would agree that in the during the discovery phase of this court proceeding, certainly we can make available for in-camera inspection the video while there are discovery matters to address between the parties. But, from the sheriff's perspective, this case is going to come down to is whether or not the Florida Today can show good cause. We don't believe that they'll be able to. And as a result, that's going to require discovery. We will want to depose their editorial board to determine what the reasons are for requests now nearly 2 years after this incident in the jail, when there have been 4 requests made, and each and every time we could have brought this action before the court. So my request is certainly going to be to give us the appropriate amount of time to respond to the complaint, to allow us to engage in any depositions necessary. I talked to Mr. Burke yesterday about limiting that to solely witnesses who are going to testify, so that we can narrow down and streamline the discovery process, so it's not something that's delayed indefinitely, or we're not, deposing 20 or 30 witnesses who won't actually witness the evidentiary hearing. But I do not believe that the rules of civil procedure go out the window under this. I believe there's the Supreme Court case that looked at that in the context of a capital collateral public record production, where the Supreme Court said, a statute cannot really override those rules of procedure. So we do believe the rules of procedure, the rules of discovery, this is a civil lawsuit as would any other be. I recognize that once that's done and we're past the discovery phase, that they would then be entitled to an expedited hearing that would put their case above any other pending cases. But I disagree that we should be ordered to respond in 7 days and not be given the appropriate time to appropriately respond to allegations in the complaint.
Anybody else like to speak on behalf of the sheriff? Okay, no volunteers. Let me turn it back to the plaintiff. The questions raised are pretty much the questions I had in my mind. Let's see if we get some answers. Mr. Burke, help me out.
Thank you, Judge Dugan. I appreciate Ms. Moody's acknowledgement that we agree on the in-camera inspection of the video. That is correct. Everything else, unfortunately, we disagree. The statute is plain. The cases that construe the statute are plain. The cases we've looked at, I can provide those to Your Honor, that address the duration between filing and actual hearing. There's one case that says that 70 days is way too long and unacceptable. Most of the cases that have been the delay between filing and hearing have been in the day.
I apologize for interrupting, but let me focus a couple of questions, Mr. Burke.
Okay.
The only reason I have any idea what the defense's defense is because you stated in your pleading, your second amended complaint, which I've read them all and studied. I did not read the attachments and all, but I read the complaint, and it's against my nature to set a trial when the defendant has not even told me what their defenses are. They may agree with you completely or they may disagree. So I went back to the statute, and in my, I didn't do a lot of research behind it, but I went back to the statute itself, and it seems to call for ultimately an expedited trial. Now, you're going to help me out with the case law, but then I thought, all right, there are times when we take it outside the standard civil case where you have a complaint and an answer, notice for trial, and then give you an expedited trial. There are scenarios. We see it all the time in preliminary injunctions, writs of mandamus, and that sort of stuff. But, and I look at the nature of this particular claim, I have absolutely no idea where the facts and where the law is going to take me. I have no idea. But it calls for quick determination. There's no question about it. But you don't have a motion for preliminary injunction. You don't have a writ of mandamus. You don't have any affirmative relief requested other than your complaint that they respond to, and you get an expedited trial once it's ready to go. So procedurally, legally, tell me how I can do the order to show cause and cut through the typical civil practice. And I know that's what you're telling me, but I'm just helping you with what I'm thinking. So go ahead.
Thank you, Judge Dugan. Yes, certainly. We disagree with Ms. Moody that the complaint by itself is not the proper initiating document. The complaint under 119.11 is self-executing. Doesn't require a motion, doesn't require mandamus. None of the case law that I've seen says that. And the reason...
What in the statute says any... I didn't see in my quick review of the statute anything more than you're entitled to an expedited trial. Is that what you're relying on, or is there something else?
Well, the statute and then the whole construct of public records in Florida, the reason it's set up this way is because the in-camera inspection of the court's inquiry is not designed to find if there is adequate evidence to justify releasing the documents, the public record. The purpose of the inquiry is to find out if there is adequate evidence not to release.
But I don't know what their reasons for not releasing is yet. I don't have a pleading from them.
Understood, Judge, and that's why we're asking in order to show cause. When a records custodian asserts an exemption, at the time they assert the exemption, they should be able to say why that exemption applies. So really it's not going to be any burden for a 7-day order to show cause response. It's different from the normal civil procedure, and the rules are different because it's a public records issue. I want to cite to the case, Your Honor, of Lightbourne v. McCollum, 969 Southern 2nd, 326, Florida Supreme Court, 2007. That's the starting point, that the government, the custodian, bears the burden of proving that an exemption applies. Then we get to the purpose of all of this is to determine not if there's evidence to release, but if there's evidence to withhold. And that's Tribune Company versus Public Records, case number 79-35504. That's part of the style of the case. Forgive me, that number. It's not the case. So the citation is 493 Southern 2nd, 480 Florida 2nd, DCA, 1986. And the only way to determine whether the custodian has properly asserted an exemption is for the court to do the in-camera inspection. And for that authority, I cite Gonzalez v. State, 240 Southern 3rd, 99, again, the 2nd DCA, 2018.
I think we have an agreement that I'm going to do an in-camera inspection. I agree with that, and we'll deal with the detail in an order, but I'll get them to get me it, and I'll look at it right away.
And the Ms. Moody raised the issue of waiver. We appreciated that. We didn't want to have to disturb the sheriff or the process server. But the normal 60-day period for responding when there's a waiver of service cannot apply here. The dictates of 119.11 require differently. And I'll submit to Your Honor these cases as well as the cases where they discuss actual duration of time from the time of filing of the complaint to the time of the hearing and what is, in those cases, acceptable and not acceptable. So we disagree with that. And again, because the custodian cannot assert an exemption and then later put together materials to support its defense of that exemption, when the under the law of the state constitution and under 119 and all the cases construing that, the custodian at the time they assert an exemption has to be able to articulate facts that support that exemption. And so that's why a 7-day order to show cause would not be a burden. And lastly, Judge, discovery is just not appropriate in this case. At least not before the first evidentiary hearing.
Well, when you say the first evidentiary hearing, that all right, I understand. We deal with the exemption, and if I find there's an exemption, then you get to go forward with the good cause reason to go past the exemption. Just as that a decent summary. Ms. Moody, what can you help me out with?
Well, Judge, firstly, I would have the court inquire as to whether any motion for an order to show cause was even contemplated. This is the first I've heard of this morning. What we were here to address is a complaint regarding their alleged unlawful, according to the Florida Today, withholding of a public record. We have a valid exemption, the security and fire safety exemption under 119.71 that we have extensively responded with regard to the expeditious nature of this proceeding. I'm going to ask the court to allow us to properly defend on the allegations they have raised. They have raised several factual allegations in their complaint. They have raised several grounds for alternative theories of production, whether there was a already waiver of the exemption, whether or not there was cause, whether or not during the course of the sheriff's duties he should be required to produce the video. And then most importantly, they're asking for attorney's fees in this action, which the court will necessarily have to determine whether the sheriff's office appropriately declined to provide the public record that was requested the record requested by the courts today, or whether there's a valid exemption. There is. And so there are things that the Sheriff's Office has to address in an answer to the complaints that they have raised. That is the law they have brought against us. They didn't file a motion for an order to show cause. As I said, they didn't file a writ of mandate. They filed a civil complaint against the Sheriff's Office alleging that we have not complied appropriately with the law. We wholly disagree. We have the right to raise our affirmative defenses. We have the right to raise every exemption that applies to the those videos. And that requires the opportunity to provide a response to pleading to each and every one of the factual allegations raised, the legal arguments that they have raised, so that we can appropriately inform the court as to the security and fire safety exemptions that are found in Chapter 281.301 as well as 119.071. And so I'm going to ask the court to permit the defendant to appropriately plead to the complaint and to answer to every one of the allegations. And then as far as discovery goes, when the allegation is that there is good cause for this court to circumvent the security features of the jail, to produce for the public security features, fire safety features from 19 cameras that takes about 47.5 hours of footage from our jail from every angle, with cameras that are able to maneuver around, to see various features of control rooms, control monitors, many security features of the jail, to be able to appropriately address the significance of that. We're asking for the appropriate time to do that. And when the court looks at weighing whether there has been sufficient documentation produced to every requester regarding this case in the form of interviews of inmates who witnessed the event, hundreds and hundreds and hundreds of pages of case reports, over 50 audio interviews with witnesses, that I'm going to ask the court to evaluate the video in connection to what has already been produced to determine if it's even required to circumvent that exemption, to vitiate the exemption, and to require the Sheriff's Office to produce material that would certainly jeopardize the security and safety of the community as well as the jail. So we're going to ask for the appropriate time for that to be conducted. I believe it's going to be important for the court to have every day to be able to watch in conjunction and listen to in conjunction with the video, to determine, is there really good cause to put this security video out in the public realm? Is there anything about the video that they don't already know and have? The answer to that is no. They have every piece of material about this case. They've been able to report on it over 50 times. So this is not a case where this is a record that would enable them to go forward with the story that they can't otherwise go forward with. They've been reporting on this for nearly 2 years at this point. So we think that there is room and there is a requirement to depose the people. And I talked to Mr. Burke yesterday about limiting that to solely individuals who are going to testify, to try to streamline that process. But we do want to know what are the motivations and why people want to.
I'm sorry, why? Hold on 1 second. There's some feedback from somewhere. Could you state your last sentence again, please?
Yes. We do believe that there is a requirement to conduct discovery and depositions at a minimum upon the witnesses who will testify to determine exactly what reason to show the court that they have any good cause, and we wholly disagree at this point that there is going to be good cause to exist. This is a story that has extensively been reported, and that's why I'm going to ask the court to look at all of the records that they have had in their possession, that they've been able to produce numerous stories from, and whether there's anything different in that video that would cause any requirement for the court to have to circumvent the exemption that would protect the security of the jail. and the concerns that we have at the Sheriff's Office about the security features, the aspects of that video that do not belong in the public realm, just simply don't belong in the public realm. But I believe that's going to take time, and I do think that we should be entitled to conduct depositions of the witnesses that they intend to call to show good cause, because we don't believe good cause exists at this stage. Not in August of 2020, when this has been extensively reported. Every agency has had the opportunity to view this video that's made any decisions with regard to any culpability in this case. And those are things that I think are going to take time for the court to review in camera. And as I said, I do not believe an evidentiary hearing in this case is a 2-hour hearing. I think it's at least, I really think it's probably more like 2 days worth of hearing time, just from the standpoint of the content of the material, the volumes of the material that I think the court's going to need to see to determine if there is anything else for the public to know about this case. Every single report, interview that the public has had access to tells the story of what happened that day. This is not a criminal case, and we do not believe good cause exists, and we believe we are entitled to the appropriate legal avenues. And as I said, as for the expedition of this hearing, we are now almost 2 years into this case. The Florida Today could have filed suit at any point in time after any of the public records requests. So they have clearly been able to write numerous stories without the video. There's nothing so pressing about this issue at this stage of the case to require the court to expedite, more so than just once discovery is done and completed, that then the case takes precedence over any other pending cases.
A couple questions raised. I want to ask a question or two, maybe make a comment or two, and then I'll turn it back over to Mr. Burke. Let me say generally, the statute says it's going to be expedited. It's going to be expedited. I'm not going to weigh into who filed what when. The statute says it's going to be expedited, and within the rules of procedure and the statutes and the case law, it's going to be expedited. The question in my mind is, do we follow the rules of procedure and let the pleadings be closed and framed, or not? But once it's ready to go, it's going to go, and you will get as quick a hearing and quick a trial as you can possibly hope for. Trust me, that will happen. This is a public interest matter. I don't know. Like I said, I don't know which way the facts and the law are going to take me, but we'll figure that out at whatever trial or hearing we have, and you'll get your expedition. Let me not leave the in-camera review. I think we have an agreement. It would be helpful probably helpful to me to have a little better idea as to what I'm looking at, what I'm looking for. But I'm hoping that the Sheriff's Office will get the recordings to my office quickly. We can devise an order. Mr. Burke's the primary movement, so I'll let him prepare an order working with Ms. Moody on the timing and the terms and conditions and limitations on it. Ultimately, the recordings will end up in the court file, so we'll need to make sure that the order properly reflects the limitations on public access to those recordings. Because again, I'll look at them and access them, and when I'm done, clerk will get them, and we want to make sure there's proper limitations. So the order will reflect that, and the clerks are real good about that. So let's leave that aside. I'm still struggling with the rules of procedure and the statute and case law concerning my ability to circumvent the normal rules of procedure and answer and pleadings closed before I can have a substantive hearing. On everything I've heard at this point, I'm not convinced that I can do otherwise. I'd be more than happy to receive briefs from both parties if you think the law supports something different. Ultimately, at the conclusion of this hearing, I'm going to ask, and there's a lot more things we need to talk about, but I'm going to ask both the plaintiff and the defendant to brief me on that particular issue. If you think the law supports a bifurcation or an expedited pre-answer trial or whatever y'all think the position is, in my research and in my review of the statute, I just didn't see it, but I'm more than happy to be convinced. Staying with the sheriff's office for a second, Ms. Moody, can we agree to that you're going to do an answer? I don't know. Can you agree to a particular time frame within which that answer can be filed? And can we also, as part of the case management, I think you've offered it, so I need to address it with Mr. Berg, but can we agree to limited discovery, limited to depositions of witnesses that the other party indicates they are going to call at the hearing? So back to you. You said yes to some of that, Ms. Moody. What about timing? You know, can we have an answer by a particular period of time? Do you need to reserve the right to file motions as opposed to an answer? I'd like to shorten those times if it is fair to both parties. And again, Mr. Burke hadn't even conceded that we should wait for that, but I'd like to case management kind of deal with the timing of your answer, the timing of any reply to your answer, limitations on discovery, and timing of that discovery. What I expect, if we don't otherwise bifurcate or have a pre-pleading closed hearing, I expect we'll get a quick notice for trial, and you will get a quick trial, unless you need a jury. If you need a jury, you're not going to trial till next year. If you are not, and I don't know if a jury's called for, but if it's trial by judge, you'll pretty much get a trial when you want it. So Ms. Moody, back to you. The questions about, are you amenable to discovery limitation orders, terms of which you worked out with Mr. Burke, and what about shortening your time for an answer?
Judge, we can certainly do everything possible to expedite our response to pleading. I was concluding talking to any of the material witnesses regarding the factual allegations. So we can certainly make every effort to have that answer in prior, several days prior to when it would have actually been due. As far as the targeted discovery, restricted discovery, the only thing that I would ask for is that we be permitted leave if, in fact, there is something discovered in the process and we're talking to witness that we think we need to follow up on. Likewise, I would ask for leave from the court in the event that we need to file any motions directed at any of the pleadings if we determine that, we're looking to file motions regarding the complaints that court today has raised. But so to answer your question, I will do everything in my power to expedite an answer, to have that certainly,
When is the answer due? When is the answer due?
It was September 12th. I can certainly have that, by the end of the month for sure. So if that would please the court, or if the court, gives us a time frame that the court is looking for, obviously we'll honor any request of Your Honor. So we can certainly expedite that process. My request to Mr. Burke was to narrow the scope of discovery, but I would ask that being said, we're not prohibited if we do learn information that we want to follow up on, that we have some from the court, if we need to. And then with regard to any motions, that we be permitted to file any motions that we believe are appropriate.
Okay. Mr. Burke, a question for you. One thing that complicates all the...
Excuse me, Judge.
Mr. Cormash, go ahead.
Thank you. I just briefly want to just add something to what Ms. Moody said. Along the lines of,
I object. More than one counsel arguing for a party. I don't think that's appropriate. We're not supposed to be getting into substantive arguments anyway here, which Ms. Moody has already done.
Normally I would agree with you completely. I'm a real stickler on that. But I would have Ms. Moody and Mr. Cromash next to each other, and they'd be able to talk. And so let's see what Mr. Cromash has to say, and I'll reserve ruling on the objection. Go ahead, Mr. Cromash.
Thank you, Your Honor. My point was along the lines of this case management conference, and I'm not going to be talking substantive matters here. My suggestion to the court is that as part of the order that results from today's case management conference is that we also get a deadline for exchange of witnesses and exhibits, and that also discovery deadline be tied to that, and it would be after the deadline for those exhibits and witnesses, so that we'd have an opportunity to depose or do any further investigation as to any plaintiff's witnesses or documents.
Okay, thank you. So let me make a note, then I have a question, actually, Ms. Moody, before I turn it back over to Mr. Burke. Let me make a note. Ms. Moody, today is August 7. Would you be able to file your answer in 2 weeks, August 21?
I think we could accomplish that if that's the court's preference, yes.
It is my preference, but it is an honest question. Not a ruling yet.
Yes,
So,
we can do that.
all right. Mr. Burke, I'll let you more or less wrap it up. What do you want to tell me?
Thank you, Judge Dugan. I appreciate that. So several points, Your Honor. This is in the realm of an extraordinary order, extraordinary relief. The public's right to access records shall not be infringed upon unless the legislature has permitted it. So that's why this procedure is in place. We're not trying to prove negligence. We're not trying to prove liability through presentation of facts. The burden is on the sheriff to prove why it should be able to withhold these documents. The fact that Florida today has attempted on a number of occasions to work collaboratively or at least professionally with the sheriff's office to obtain these records, and that's taken, it's been almost 2 years since Gregory Edwards' death in custody. The fact that time elapsed has nothing to do with this, and that probably reflects Your Honor's comments about the need for an expedited hearing. Just briefly on the number of articles that my client has printed on this, that has nothing to do with...
May I say this real quickly?
Yes, sir.
At this juncture, that's irrelevant to me. At this juncture. Now, there are some factual disputes that I glean simply from reading the plaintiff's argument, and in your second amended complaint, you were covering anticipated defenses and anticipated responses defenses, which I recognize is very helpful. But one factual dispute was if, in fact, and I'm not going to state the legal words properly, but conceptually, factually, if in fact the sheriff is able to establish the security needs for withholding all or part of what you're seeking, then you had in addition to the good cause, they're probably part of the good cause, you had an argument that they've released it so many other times in so many other matters that there's nothing to protect. So that's a bit of a factual dispute that I think the parties probably need to be able to investigate a little bit, right? Well, the reason, again, I go back to, I don't know how I can make a proper decision until the positions of both parties are framed. And quite frankly, you have a pleading. I know what your pleading is. You're limited to your pleading. If they don't have a pleading, and they can say anything, raise anything, until their response is framed, and they're limited to what their response is, and we know what we're trying. I continue, and I'm going to let you brief it if you want to, but I continue to think I need to have your position, your Second Amendment complaint, if that's what the ultimate pleading is going to be. I need to know where you're coming from, and you're limited to that. I need to know where the sheriff's coming from, and they're limited to that position. We can talk about limited discovery, but that's my starting point. So there's not a ruling, but as I need to do further research, but that's my starting point. So, again, I apologize for interrupting. Go ahead and tell me what you wanted to tell me.
Thank you, Ron.